Title VII was the first major anti-discrimination legislation that drastically affected employment decisions. Although it had great impact on the employment relationship, it was not the first anti-discrimination statute passed by the Congress. Shortly after the Civil War, Congress passed the Civil Rights Act of 1866 to support the 13th Amendment, which gave non-whites the same rights under the law as whites. The Civil Rights Act of 1866 was an act to protect all persons in the United States in their civil rights and furnished the means of their vindication. The act declared that all people born in the United States who are not subject to any foreign power are entitled to be citizens without regard to race, color, or previous condition of slavery or involuntary servitude. So this is a similar language as the citizenship clause in the 14th Amendment. And it also has similar language to that of the Equal Protection Clause in the 14th Amendment. In particular, the Act discussed the need to provide reasonable protection to all persons in their constitutional rights of equality before the law. There are something we need to be aware when we compare the Civil Rights Act of 1866 with the Title VII of Civil Rights Act of 1964. First, the penalties were left to the individuals involved. In the case of Wynyard versus King, the director of a municipal-owned hospital, contrary to the procedure in the employer's handbook, he discharged an employee without a hearing. The court held the director personally liable, but not the hospital, since it was part of the municipality, which couldn't be sued. Even if it could have been sued, the city could only have been held liable if an employee's action was based on the policy that is unconstitutional. Similarly, when a prison guard placed an inmate in a cell with another inmate whom he knew to be dangerous, and the plaintiff was assaulted, the guard was held personally liable. And in addition to this personal liability, the plaintiff does not have to show intent under the Title VII and the Civil Rights Act of 91 Amendment when punitive or compensatory damages are asserted. If the plaintiff's attorney used both statutes and the intent cannot be shown, then it is still a violation of Title VII, where the only remedy is to make the employee whole. By making the employee whole, we mean to return the employee to his or her former status that he or she would have been in, but for the employer's wrongful conduct. Another difference is that the plaintiff does not have to go through the Equal Employment Opportunity Commission or the other administrative agencies if they sue under the Civil Rights Act of 1866, but they can go directly into the court. And in reality, this sometimes is a great advantage because if you want to save time, desire to address this quickly, then this is a better way to go. In reality, the activities of the far-left racist group, such as the Ku Klux Klan, undermined the act. It failed to immediately secure the civil rights of African Americans. And normally people who are being discriminated against had very limited access to legal help, which left many victims of discrimination without recourse. So the federal anti-discrimination law had come a long way, but the civil rights journey is still underway. Thank you.